Aaron. I'm a PhD student here at Maynooth University and a John Platinum Scholar with the Department of Law here in Maynooth. It's a pleasure and privilege to be here today with so many esteemed practitioners and academics, and hopefully my contribution here can make a lively contribution to the discussion that we're going to have over the course of the next day or so. So my doctoral research examines peace agreements, ways to improve their stability and their enforcement. So as a legal scholar, I'm primarily doing peace agreements as legal documents and how the formal legal status of peace agreements might find ways to improve their enforceability. Now, some of you might be wondering what a legal scholar can bring to a mediation conference and how law can play an effective role in the processes of conflict resolution. Some people might feel that this is perhaps something that's best left to political diplomacy and mediation itself, rather than law. However, international law has traditionally been seen as the great mediator, as a basis for a legal order that is neutral between the parties. And indeed, in recent years, those in the international development community have started to see reconstructing justice systems and re-establishing the rule of law as the centerpiece for making peace work. International law plays an obvious practical role in making peace agreements work. It can provide for processes of implementation by making precise guarantees a part of the agreement text. They can also provide for processes of compliance monitoring, such as disarmament of combatants and UN peacekeeping missions and so on. And also they can provide for enforcement of an agreement where necessary. So as I stated there, peace frameworks, timetables for implementation, and provisions for UN verification are all examples of legal measures that can build trust between the parties and lock in repeated, non-hostile interactions between them. Legal instruments also have the advantage of channeling state behaviour towards expected outcomes, and they can provide for remedies and or consequences in the event of a breach by one or more of the parties, much in the way that contract law can provide for remedies in a domestic context. And in these ways, I argue that legalised peace agreements, or peace agreements with formal legal status, are to be preferred over those with a predominantly political nature. So what's the problem then? If legal status brings all these advantages to peace agreements, why then aren't all agreements seen as legal agreements? Well, the problem lies with traditional concepts and traditional teachings of international law. International law has a tendency to reduce the broad range of legalisation that occurs in the international sphere to a binary choice between hard law and soft law. Now, when I say hard law, some of you might not be familiar with this concept. It's the idea of a law that is enforceable by a police force and interpreted and enforced by a court system. So in a domestic context, we have that here now. We have Garda Síochána who apply and enforce the laws on the streets, and the courts who interpret the laws and apply them in their judgments. However, on an international scale, it's very hard for any law to live up to this standard. We don't have an international police force or an international policeman, and while we do have an international judicial system and some international courts, not all countries in the world are bound by these courts. So as I said, most peace agreements then tend to fall into the soft law category because they do not have people to enforce the law with regard to peace agreements. So this narrow view of hard and soft law is exemplified by the primary institutions and instruments that make up the international legal order. One of the main legal instruments in international law is the Vienna Convention on the Law of Treaties, which is the foremost contemporary source of treaty law. So this convention was convened in 1969 to codify all the existing customary law on treaties that existed at the time. And it states that only an agreement between two state actors can make up a treaty. So a treaty is only binding if it's made between two or more state actors. So effectively, agreements between states and non-state actors, which might include armed revolutionary groups or militias, those kind of agreements are denied the benefits of the provisions under the Vienna Convention on the Law of Treaties. Similarly, the International Court of Justice, which is one of the primary institutions of the international legal order, this also adapts a very narrow view of international law. And in my research, I've come across two cases that perfectly exemplify this narrow view. The first case is the Lusaka Armed Activities case in the Democratic Republic of Congo, And in this case, the International Court of Justice refused to grant legal status to a ceasefire agreement in the Congo. And in doing so, in their judgment, they overlooked the importance that formal legal status has in terms of making a peace agreement work. So they really attributed little importance to how important legal status is. The second case is the Lome Accord amnesty in Sierra Leone. And in this case, most critically, the court made a distinction between agreements that are used to end civil wars or intrastate wars and agreements that are used to solve international conflicts. And in doing so, they ascribed a much lesser status to those agreements that end civil wars. So effectively, what this means is that conflicts involving non-state actors, conflicts involving armed groups or militias, as I said before, these kind of agreements, which are arguably more in need of recourse to international law, are deprived of the advantages associated with formal hard legal status. And this, in turn, greatly undermines the utility of internationally brokered settlements as a device for ending civil strife. So what's the alternative? Well, what I'm arguing for you here today is for more pragmatic approaches to conflict resolution that achieve the normative aims of the international legal order. So when I say the normative aims, what exactly are these aims? Well, international law was originally founded on the necessity of a legal order for the satisfaction of needs and the pacification of social life. But one only needs to look around the world this morning to see that the pacification of social life does not exist, and the international legal system has hardly contributed to this state of affairs at the moment. I'm arguing that in our legal approaches to peace agreements up until this point, we have been true to the legal doctrine and teaching, but we have not been true to the values that underpin the legal system. Values such as preventing disputes internationally, preventing the arbitrary use of force and genocide. These are very utilitarian outcomes that we should seek to achieve. We shouldn't get caught up in the legal pedantics of the matter. We should rather focus on the outcomes that we should want to achieve as a global society. And the quote there reads that the formation, transformation, and dismemberment of states as a result of revolutions and wars create situations which cannot be met by the application of the normal rules of positive law. So war in itself is the crudest expression of the rejection of law. So how can we expect law to work in this type of environment? What we have to do instead is be pragmatic and flexible in our approaches to conflict. And that's the only way to rehabilitate these damaged societies back to peacetime. So this pragmatism that I'm calling for is not entirely unprecedented. And in my research, I've examined 3 case studies that exemplify pragmatic and flexible approaches and applications of the law. The first is the Dayton Agreement, which concerned the conflict in former Yugoslavia, most notably Bosnia and Herzegovina. And under the Dayton Agreement, several of the signatories were actually non-state entities. So namely, the Federation of Bosnia and Herzegovina and Republic of Srpska were both sub-state federal entities as part of the greater Yugoslavia. However, the international community treated their obligations under the Dayton Agreement as formally binding, and thus these sub-state federal entities were allowed to complete their obligations much in the same way that the state would. Now, while this involved a lot of legal wrangling and wriggling, in the end, the Dayton Agreement, though fragile, has left a lasting peace in Bosnia and Herzegovina to this day. The second example is the Supreme National Council of Cambodia, which is another legal anomaly, which remains unprecedented up until this day. In the aftermath of Cambodia's brutal civil war, the UN wished to assume trusteeship or administration of the entire nation of Cambodia in order to transition it successfully to peacetime. However, at the time, there was no political actor in Cambodia that could be said to have the legitimacy or a legitimate claim over the state apparatus of Cambodia. So in the absence of a suitable actor who could delegate the sovereignty of the nation to the UN took the most practical approach to the problem and simply created that kind of an actor. So as a result, the Supreme National Council was created as the unique legitimate body and source of authority in Cambodia, in which national sovereignty and the ability to represent Cambodia internationally were enshrined. The UN Security Council and all of the parties to the Cambodian peace process recognized the authority of the Supreme National Council to express the collective will of the Cambodian state, despite the fact that none of the parties to the agreement actually recognise it as the official government of the Cambodian people. And to this day, as I said, its creation remains independent of any established principles or procedures in international legal teaching, but it was central to Cambodia's successful transition to a peacetime democracy. And finally, the Abbot word concerns a contested territory caught between North and South Sudan that was the subject of much fighting during the civil war in that country. Under the terms of the Comprehensive Peace Agreement in Sudan, Abbot was made subject to judicial arbitration. Now, at the time, the arbitration panel's findings were criticised for being too result-orientated and for the many self-contradicting conclusions that existed in their judgment, which many claim came at the expense of legal accuracy. However, from a purely pragmatic or utilitarian perspective, the award was a sophisticated piece of diplomatic and political flexibility, which prevented Sudan from regressing back into civil war all along its north and south border. So while the decision in the Abbot award came under much criticism for its legal inaccuracies, one only has to look at the outcomes of the award to see what was the better outcome. In the end, though controversial, the decision actually saved the Comprehensive Peace Agreement from collapsing, and the findings of the panel were accepted by both parties. So the Abbot award and the other two examples all evidence the extent to which the law will bend before it ultimately allows the peace agreement to break. And I'm arguing for this kind of flexibility throughout international law. So to conclude, Chris Okeke, an influential Nigerian scholar, wrote back in 1973 that if international law failed to influence and to regulate adequately the course of international relations, it would have lost its value. And I'm arguing before you today that international law has failed to regulate adequately the course of international relations. We're not stuck for examples of this throughout the world this morning. If anybody just wants to look at the front page of the paper, the ongoing crisis in Syria, the recent fighting in Palestine and Israel, and the ongoing situation in Ukraine, which itself is a parody of international law, with both sides using international law as a valid excuse for their actions in the territory. One only needs to look at all these examples to see that the international order is not working at present. I'm arguing that we need to reassess the current international order with a view to achieving the goals that are in the greater interest of our global society: international security and stability. At present, these goals have been compromised in favour of legal pedantics. So in seeking an alternative, we need to be not so stubborn in our opinion, nor academic in our analysis, but rather more pragmatic in our approach and successful in our outcome. And thank you very much for listening.